go ahead.
Oh, and then the proper focus is on the message that the initiative proponents put forth, and what's written in the literature, that looking at proponent intent is the better way than looking at voter intent. Which it seems like both courts did.
Yeah.
So that's good.
Well, the kind of argument I tried to make in the unconstitutional animus article is like, animus is really about function, sort of segregation function, but you can find evidence of it where you have that, campaign literature or whatever. But that's a thorny question. But right, if you're going to say there's something that's analogous to a discoverable legislative history, it would be much more like the campaign literature they're trying to figure out. Yeah, that actually would be great to hear how to cite that article.
And he says that if courts do focus on the proponent's intent, it will force proponents to be rational, reasonable, thorough in what they put forth, which I actually really think that's a good argument.
Well, that's what I'm talking about too. So I guess, so it's Kenji Yoshino, I think, who coined this term about reason-forcing conversations. And this article that I'm going to be submitting tomorrow talks about suspect classification analysis and trying to kind of formulate that so that legislatures do have to give reasons for why they choose to single out a particular group, and not under rational basis review, not allowing this sort of wild speculation about what, the reasons why a certain law was enacted.
You're submitting it to law reviews tomorrow?
Yeah.
Good luck.
Thank you. Yeah. It is, yeah, it's, what a process, The first article I wrote was about 18,000 words, and this one's now like almost 27,000, and I can't believe what a difference it makes. Could you shut is the door still open?
Yeah.
Thank you. It's just harder. It's harder to get it done.
Yeah.
It's been eye-opening. But it's been good. So I'm a little giddy with excitement about everything going on, so I'll try to calm my affect a little bit. But I'm really looking forward to talking to you guys today about the transcript. So since we'll probably go over with our discussion, or take it to the end of class at least, I wanted to go ahead and schedule conferences with you guys, if that's cool. So, and Bill, I don't know if you wanted to come in an additional time. Like Allison had also this class on Monday, and she's coming in on tomorrow.
Sure. Are we?
Well, we talked about the topic sentence outline, and some people had kind of varying, levels of development, but sort of had that check-in point of your first effort of the topic sentence outline. What are the process issues, what are the content issues, or whatever. So I think is it possible, you think, to meet again this week, or?
Yeah, I think I'll be up here Friday.
Okay. What time?
I will be free. Alexis, do you know when that makeup class?
Yeah, it's 1:15 to 2:30.
So I'll be free after 2:30,
okay,
and probably before. I can make time before 1:15 too.
Okay. I'd love to meet you after.
Okay.
Are you going to stay here and study? I'm sorry. Are you staying and studying after? Or I'd like to meet you at 4, but.
Okay.
Is that okay?
Sure.
Okay. So bring your topic sentence outline with you. Okay, then let's just nail down meeting times next week. Go, just throw it out.
Anytime, or are there days you prefer?
No. I have just a few things on here.
Okay. Do you have any time, I guess, either Tuesday or Thursday between 12 and 2:30?
Yes. Let's meet at Tuesday at 1:30, 2:30.
Okay. And that's when what should we bring? Or we can talk about tomorrow.
Yeah. Well, we're talking about a rough draft at this point, especially of the primary, the gut of the opinion. Okay. Allison?
So, do you want a separate appointment from tomorrow?
Yes,
Okay.
yeah, this is all next week, because we don't have class next week. Next week is set aside for conferences.
Oh, I see, okay,
Yeah.
so this is the week of April 1st through 7th?
Mhm.
Okay. I'm at school Tuesday, Thursday. Oh, so we don't have class next week. Oh. Well then, Monday or Wednesday evenings, Tuesday, Thursday, during the day or evening, really.
You want to do 2:30 on Tuesday?
Yep, I got a class at 1:50. I'm sorry, no, I got a class at 2:30.
Okay. Kara?
Are you free at 1:30 on Thursday?
I'm doing one of these marriage equality forums, so I don't think I might not be back.
I'm going
Oh, okay.
Just kidding, sorry.
Do you have time after a little bit later?
I have class from 2:45 to 4:25.
Okay.
Could you do it before the lunch?
10:30?
Yes.
Okay.
I have class till 10:15, but I will be there
Okay.
at 10:30.
Great.
How's Wednesday look?
Wednesday's pretty open except for my workout.
I don't need to
can
join
run
you.
outside.
I need to be on the treadmill. How about just like during regular class time Wednesday?
Yeah.
So you're wanting us to bring in a rough draft for this meeting?
Yeah.
That would be really tough.
Rough
This
draft?
weekend is really packed.
Well, when we talk on Thursday, let's set a realistic goal for you.
Okay.
Okay? I just want to do my part of pushing you guys to move the ball forward and not letting stuff build up too much, so.
Yeah. I was gonna do the comparative case chart.
Okay.
Wednesday,
Yes,
if
that's a
fine.
good idea.
Okay.
Okay. Bill?
I'll do Wednesday. Can I meet you just before Will then?
3:15?
Sure.
Great. That's perfect. Okay, great, guys. Okay, so no class next week, and hopefully, if nothing else, you can use the class time to do a little bit of writing. But yeah, I want to, be there talking to you guys about the writing process and giving you some guidance about the writing process. I don't want this to be a class where you're just kind of left on your own to figure out how to write the paper, especially because we're doing a judicial opinion. Okay, any questions about what's coming up?
So it's Monday the 29th that the final draft is due? Or is that right? Okay.
Yeah.
I can get a draft done, I just can't do it this weekend. So
No, that's fine. Like I said, I want to figure out something that you can do, even if it's just
Yeah.
in class time on Monday, to
Okay.
push the ball forward.
Okay.
And then we'll set goals for the next week and the next week,
Okay.
just kind of make sure we're staying on track with stuff. Okay, yeah, so no class next week. Week after that, we have guest speakers. So again, not a lot of prep and stuff for you guys, all right? Nice. Okay, so let's talk about this, this oral argument transcript. Did anyone listen versus read? Do both and have a different opinion?
Yeah. You could listen, yeah. I thought it didn't go up yet.
Yeah, they put
They put it at the same
the
time.
audio and then the transcript after, or both at the same time?
I think that was the same time, yeah. Not that I was obsessively checking.
I went back and forth. I started listening, and then I was like, I don't know who's speaking. I
Okay.
don't know which justices. So then
Yeah.
I started reading.
Yeah.
And then I was like, oh, they're interrupting me. I wonder what that sounds like. So then I listened and read along.
Oh, that's cool.
Yeah, I mean, it was like,
That's like having a teleprompter or whatever
It
it's
was
called,
cool.
like closed captioning.
yeah.
Nice, okay.
It was probably a little distracting by being like, oh, the transcriber transcribed that differently. But it's interesting to because then you can know who's speaking, but you can hear the intonations and hear I just thought it was fascinating how they all interrupt each other.
Yeah, no, it is. And then Chief Justice Roberts actually had to intervene, I think, at least once. But
Yeah.
so, because I decided to only read it in the transcript and not listen to it because I had this idea that I want to not be affected, by tone of voice or presentation or whatever. But that's definitely. I mean, it's kind of ridiculous. What are you supposed to get done in oral argument? Right? I mean, there's no discussion of suspect class. Well, there is a little bit of suspect classification, but I mean, and I think they went after the standing issue because they're interested in it and they have questions about it. But I think a lot of people think standing is going to be the dispositive issue, and I'm not sure that's true. But anybody else reflections on?
Did it sound as hostile as it read? I mean, between especially some of the justices, like when
that-
Scalia made that
with
comment
Olson
about,
and Scalia.
or he made a comment about one of the other justices, like they weren't elected during Strom.
Yeah, I think he was talking about her age or something. I'm not
Right.
sure what that was.
I was like, put a note to Google
Yeah,
like,
with Kagan.
who that
Yeah.
guy, whoever that
Yeah.
was.
Oh, he
Did it
was,
sound as hostile as?
Yeah, sometimes it sounded hostile, and then the laughter and the or it must be
Yeah,
the
that was
gallery.
strange.
Yeah, then you guys like read laughter, and so I was like, oh, I think maybe that.
See, I was actually laughing out loud when I read this. My boyfriend was looking at me like,
Yeah.
"Oh, judicial humor."
So I was talking to somebody about that. Apparently, Strom Thurmond had kids like into his 70s. So Scalia's joke was like,
I
after
thought it
she
was
had
about
said,
that she was like liberal.
No.
I thought it was that she was young when
Yeah,
I read
young,
it,
yeah.
because she was talking about the couples
Yeah.
over 55. And I guess he was making a Strom Thurmond joke because he had kids forever.
Okay. That's good to know.
What a card! What a card!
I thought it was like mean at her about being a liberal or something.
No. But then, yeah, this fascinating, and there was an article on Legal Theory blog about this idea of, when does a pile of sand form? So, no, stick with me. So you've got one grain, that's not a pile. You got two grains, that's not a pile. Like, when does it become a pile, right? Some sort of like philosophical tool or whatever. And you have this whole thing of Scalia being like, when did this become unconstitutional? And really trying to back him into a corner on that question.
What kind of answer was he looking for with that, though? I don't understand.
Why didn't he just say 1868?
Yeah.
Like,
Yeah.
when the Equal Protection Clause was added to the Constitution, that's when this became. I didn't know why he didn't just.
Well,
what's the trap there?
I think,
Yeah.
I think that's a good point. Right, so the idea is like this principle of equality has always been there, but it takes us time to figure it out, right?
But he was saying even like with Brown Board of Education, that it started then, but then that was so incongruent to the fact that we didn't recognize it until whenever that
That's
came.
just-
Like,
that's a tough
I
question,
didn't get what he.
yeah.
Well, I mean, it's a tough question because there isn't really a right answer, but I didn't get what Scalia was trying to do.
I think Scalia was trying to get him to say, our views about sexual orientation have evolved over time, and it's like, well, the Constitution doesn't evolve.
Yeah.
Constitutional principles are constitutional principles, they're bedrock, da-da-da-da. I mean, that's his belief. You don't have this kind of marriage of principle and then evolving social norms, in Scalia's worldview or whatever. So that was the trap. And it's tricky because I think a lot of people on the advocate side are very cognizant of the change, the social and cultural change with respect to this issue. So maybe that's why he wasn't, kind of thinking clearly about it. And then, then there's also, how could this be, the unconstitutionality of this be concurrent with the Equal Protection Clause when, this wasn't an issue. Homosexuality wasn't a recognized identity. No people were trying to get into same-sex marriages, whatever. But I think, that's a fair question. So what I want to do, and we can just kind of have a free-for-all, I don't care, but what I wanted to do was actually kind of move through the transcript and try to pinpoint on our equal protection flowchart what issue the justices were talking about where. Because they touched on a lot of different issues. I think people who are not well-versed in equal protection law wouldn't necessarily realize what was going on. But because you guys understand this area of law, you will be able to tell that and just to kind of, see what we can determine from that, okay? So, any other global responses though?
I'm still just not getting why, what Bill said, why that wouldn't be okay. To say, just like you're recognizing Justice Scalia, that Brown, the right in Brown, they started with when the 14th Amendment was enacted, this one too. Then what do you think
I just don't think it
Scalia's
occurred to
response
him.
would be?
I don't think it occurred to him to
Yeah.
say that. I think is the big issue. I think his thing of, well, when did interracial marriage become unconstitutional was an excellent retort.
Yeah, it's a great point.
Well, yeah, because the founders obviously did not contemplate interracial marriage.
No.
And yeah.
Even in the Constitution Amendment.
Yeah. So I don't know. I just feel I do feel like because people are so cognizant of the dynamic social change around this, that it just didn't occur to him to respond that way.
Mhm.
But I don't know. It's hard to say.
But I think that I think Scalia, if he had responded that way, he still had a plan. Scalia, I think that even
I'm sure
if
he
said
had
I
a plan. He would have like mocked him, right?
Yeah, but then, that's so I just didn't like that.
Well, Scalia, he has this view that, the court's job is to preserve values, not revise them, and to really look to the past as opposed to the future on these issues. So I think, he would probably back him into a corner of, acknowledging how recent this development was, this social movement, and saying that it couldn't have been in the contemplation of, the Congress when the 14th Amendment was passed. But Okay, so let's take a look. Did you guys think the advocates did well? The
I thought
attorneys?
Ted Olson was pretty impressive. He kind of broke some of the rules, with like answering a question with a question and stuff, but
He's got some.
he presented himself as an equal.
Yes.
Whereas like I felt like the first guy got beat up some,
Cooper.
and then when Olson was up there, it was like.
He's like, I've done this before.
Yeah,
This
yeah.
is my first one.
Yeah.
You're not my superior.
He didn't say or honor them much. He like said,
Isn't that interesting?
And he like interrupted them, and yeah, it was much different from Cooper to.
And I don't think every attorney could get away with that. So, okay, so you have this sort of, this dynamic where both of the attorneys want to start out talking about the merits, right? And then Justice Roberts kind of directs them towards talking about the standing issue. So this is, this is to the further left on our chart here, but what was the gist of what you got about the standing issue? It's kind of... There are a couple of themes running through this. Is it bad that I erased that? Or is that
There was the public action piece.
Okay.
And they talked about like why this group of individuals has standing to defend for the state. Because then can any individuals bring a case for any law?
Can the states just pick who they want?
Yeah, right? So this idea of being authorized. Which I don't find the state had a process of authorizing these. They had this law in place, and they had a Supreme Court decision, examining this case against that law. So, this was one concern. It was sort of almost like, I just don't know that's the court's business. But can the state take this action of saying, okay, if we, the executive branch declines to enforce a law, defend a law in court, then we have this process of authorization. That seems like...
I thought it was almost a separation of powers issue if you get into that, because then it's like the executive branch approving the law.
Yeah.
It's either, if the appeal goes through a first round judicial review with the state before you even have access to the courts.
So yeah, it's that kind of question is who's being represented by whom, right? And what I feel like the court is suggesting with this line of and also to say that it's separate, the state saying, yeah, we will permit these people to stand in our stead, right? The state would otherwise be defending this law, and we elect to have this other group do it. Separate question of Article 3 standing, and you have this language about proprietary interest and kind of like what's the injury here, right? And is that, you guys like taxpayer standing, that whole, you can't just, sue based on taxpayer standing or whatever, do these people have an interest that is distinct from other members of the populace? To me, it seems so clear that they do. I don't know.
But why? What's their interest?
Especially post-election, as opposed to pre-election.
Their interest is in, okay, so, right, you have the pre-election. Pre-election is pretty clear, right? They're doing work to make this happen, right?
Yeah.
And they have a right to a fair process there, as the advocates, as the proponents. What is their interest post-election?
To see the fruits of their labor, maybe? Just that they had this passed?
Yeah, they talked about the money they spent on it and gathered signatures and all of that, but there was...
Which of course still seems pre-election, right?
That's true, that's
right? The law could be changed and they couldn't, definitely the world changes after the law is actually voted on and put into place. What exactly are proponents losing here? What's being taken away from them?
It seemed a little bit too like just like the prestige of the institution. And that was kind of part of their discussion.
Okay, so then they go, not, well, and that's a trickier question, right? Could some random heterosexual person be like, I have standing to, support Proposition 8 because allowing same-sex couples to marry injures me and the sort of dignity of the institution of marriage, and I think the court, would not let that fly.
Get too close to the taxpayer.
It's generalized, right? It's a generalized injury, and I think also the sort of cause and effect is very difficult to prove, and I talked about that a little bit in a different context. The normal course of action is that, I think it does kind of go to separation of powers, right? So if you have this, it goes to two things, separation of powers and the special fact that this is an initiative, a popular initiative, right? How does that change things?
That's the fear on the other side. To me, there are fears on two sides. One side is you have the state dictating who has Article 3 standing. Now on the other side, it's the fear is that you have a democratic process that can be defeated by the public officials you were trying to get around.
There's no way to
question.
I think that's right, and that's what Justice Alito said, right? Was the foundational fear or whatever. So in the DOMA case, you have this question of, okay, well, Congress enacted the Defense of Marriage Act, and then the Obama administration ultimately decided not to defend that, and that's kind of between those two branches of government here, right? Here you have a different situation because it's a referendum, and people are trying to take matters into their own hands, but as soon as it gets into, under government control, they take that power away again. I don't think you can say that.
But it's not the legislative branch that's taking it away. It's the legislative.
No, it's the executive.
By refusing to defend.
Okay. Because they're trying to get around, I feel like they're trying to get around legislative, executive, and judicial branches by doing this. Because they didn't like the court decision legalizing gay marriage. They didn't like the fact the legislature hasn't done this. And so it's like they're trying to circumvent all of that.
Or exercise their rights. we've revealed your common man before in this one. No, I think that's right, and that's what I love about these cases too, because it's all about federalism, separation of powers, direct democracy versus electoral democracy. My instinct is that yes, proponents are losing something; they're experiencing a real injury. By not, being permitted to defend the law through the court system.
But why would it be specific to them and not everybody who voted for it?
You only need like a member of the class to be a party to the case. You don't really need.
Well, so that's true, but the question is more: is it so diffuse, right? Again, that taxpayer standing issue. So is that interest so diffuse? And I think, thinking like human beings as opposed to thinking like lawyers. Obviously, these people care a lot more, right? They put the time and energy and the effort into it, and you could say, they have some sort of entitlement to this post-election process of defending the law. That it doesn't have to be by the state, but then the state has to permit them to continue, in a sense, to continue being proponents of the law until it goes, so election maybe isn't the cutoff point, is actually after it's been tested in the courts. But then what's the limiting principle there? What happens if the challenge to the law takes place 50 years later? Is that different? Is it different with DOMA because it was, some 16 years later that the executive decided not to defend it? I think these are very interesting questions. My gut tells me that it is offensive to the sort of direct democracy, respect for direct democracy, to not find standing here. But
then couldn't I think one of them kind of one of the justices made it basically like a slippery slope argument that what's to stop this from, whoever being granted that, whether it's, because they talk about that there were all this process, but couldn't the state grant anybody standing to defend if they wanted, or?
Well, wouldn't that be just like appointing special counsel? Okay, so that's the other question. Who has to experience the injury? Is the state essentially assigning its standing to the proponents, right? So it's clear that if the state has standing, which it clearly does to defend its laws, doesn't that transfer over to the proponents if they're authorized under state law to assume the responsibility of defending the law? I mean, that might be a way.
But I don't think, I mean, but that's potentially permitting a state to determine, I think Justice argued this too, to determine federal standing for whoever the law is.
See, but Article 3,
individualized depending on what the state, whatever state decides who can represent it.
Right.
Right, so yeah, that made me question whether this would be a completely different argument if there was no California statute saying that proponent initiatives get to defend it as the state declines.
Well, what if the Article 3 question is answered when you say the state has standing? And then the only question is, the second question is, can the state then confer that on another party? Because this, I mean, Article 3 standing is met, you know, for the state.
Mm-hmm. Yeah, but then it creates a problem of, depending on what state you're in, you can have standing or not.
So
or whatever issue they find important, you know, I mean, it becomes kind of arbitrary depending on the state, and it's no longer a federal forum in the fact, I mean, it is a federal forum, but it's no longer a federal forum in the fact that states can decide whether or who can go before an Article 3 court.
So, but see, doesn't state law often define what constitutes an injury?
I mean, for like diversity jurisdiction, but not for, in Article 3 jurisdiction constitutional issues.
I think it's a really, I mean, I don't know the answer to this. I definitely, you know, like I said, my instinct is the court won't go there,
like
but.
Circular almost works, like if you go straight to Article 3,
Yeah.
and then the state has the ability to delegate to its citizens, I mean, that brings us back to the initial, they can choose who can represent their law, and then they have the first round of review whether or not to appeal their law or delegate to someone else. So it's like
the concern here is that is arbitrariness and this sort of this idea that can the state transfer its injury? Because we know the state has an injury, but can it, you know? And I'm just trying to think through this a little bit more clearly. But what would be problematic? What's problematic? I mean, it's not arbitrary, right? The state has a law that is, you know, they've designated a mechanism for making this happen, right? So I think the arbitrariness concern is dealt with.
Is the standard for Article 3 standing proprietary interest for a party to intervene as well, in addition to just bringing suit?
It is getting a little well beyond my area of expertise.
I don't know if it was
I don't know
the standard.
Yeah, the intervener. I mean,
because then maybe.
Yeah, I don't know. I don't know the answer to that. It'd be interesting topic to research.
Well,
yeah.
What was Olson getting at when he was trying to get in? Like, it seemed like he was trying to sneak in that TAM is no longer one of the
that was weird.
petitioners. He was like saying because of his conduct during the election.
I think perhaps, you know, there were maybe some unfortunate statements made, something like that. I mean, I thought that was like a trial lawyer tactic. That's really obnoxious thing to say, but I thought that was kind of, I don't know.
It is interesting though, I think, in the context of if there's this group that puts forth the initiative and that group then changes composition because somebody leaves or, you know, someone comes into it, that makes it even harder to concretely transfer state injury to somebody in particular.
But I think, you know, the question is really the remedy, right? Because there has to be a remedy. I mean, it would not be the right result to say, you know, these people work to pass an initiative to circumvent the government through an act of direct democracy, and then the executive decided not to enforce it, and there's nothing they could do. I mean, that can't be the right answer. So it's really a matter of, you know, what...
Well, I mean, Perry filed the case at the beginning, too. I mean, like, there was definitely standing there for that case. It's like...
For the, so Perry and Brown,
and the state had standing to
initiate the case, but you have to keep standing throughout the proceedings.
So the state defended at the district court level, right?
Yes.
So if they decide on standing, the district court decision stands.
That's a really complicated question. It's not clear. It's not clear what would happen because, I mean, that seems intuitively right, right? There's nothing
Because then they would have the right to
problematic.
appeal in the Ninth Circuit, so we'd be back down in the district court.
Yeah, no, you would just be left with a
Vacate.
district court decision, with its effect in California, and, you know, I mean, the reasoning wouldn't have greater precedential effect necessarily, but.
Yeah, it's just very convenient. I mean, it's a very convenient solution for them. They can confine
But why would they
it.
have granted cert just to kick it on standing?
It seemed like they
Well,
were
I don't know
ready.
what-
I know, they were ready, it seemed like they were in some ways,
Do we know
but,
what group granted cert?
no.
I mean, which side?
What do you mean?
I mean, liberals,
Oh,
conservatives.
No,
Which judges, it just comes down to support, right?
they don't flesh it out, you know, they don't flesh out all these issues at that time.
Do they decide granting cert 5-4? I mean, it's like, is it?
I think 3 or 4 of them are required, right? Not actually a majority.
I'm not sure. I'm really, yeah, I think it is a different
There's
rule,
a
but I'm
certain
not.
number of them, and I think it's 3 or 4 have to okay it.
Yeah.
So either wing could grant
Speaking
cert.
in political terms.
Yeah, but I mean, you know, but think about how
Well, the
this
cert
plays out
agenda is
there.
different than the merits agenda,
Yeah.
right? I mean, they don't want to grant cert because they actually think this is a great case.
Right, that's
to
what I'm saying,
say
and then
there's no
another,
fundamental right.
then another
Essentially.
group can say, you know, maybe the conservatives thought this would be good, and then the kind of other justices think maybe not so good. But-
Yeah, and it just would be hard to decide not to grant cert on the standing issue with that limited level of process, I think. I don't know. You know, it's like sometimes you have to get in there and get your hands dirty to realize what's actually going on.
Yeah.
It's like if your real goal is not to get out in front of democracy, like if you really
As
want
a general
the
proposition.
general proposition, you want the court to kind of hang back, then this gives you an out. Somebody in California, like Roberts was saying, could bring basically this exact same case again. You know, it takes a couple years to get through. They haven't set any precedent nationally
Right.
here. You can decide DOMA on the federalism stuff, right? It's just not.
Yeah, I mean, DOMA is, I think, going to be,
So then you've basically done nothing. You've effectively done nothing.
yeah, the DOMA decision will not have implications for marriage equality.
And you've bought yourself a couple years
Yeah.
to let everything shake out and then come back to it.
So, okay, so,
They must just leave it a state issue and don't even really get involved at all.
yeah, so these are kind of the big things, right? Let's go ahead and talk about it. How could the court, well, what could the court rule? All right, so in DOMA, it's like none of the Fed's business, basically, right?
Yeah.
Which is interesting because really, the federal government's not doing anything to the states. I mean, right, so you have all these different state laws doing X, Y, or Z, and you have this federal overlay, you know, well, if the state says it's a marriage, we say it's a marriage, and then DOMA comes along and says, oh, except, you know, we don't recognize same-sex marriages or whatever. It's really not doing anything to the states. It's doing something to their citizens, you know. But it's you know, there's indication to the extent that oral argument can give you a clue about where the decision is ultimately going. Justice Kennedy seemed very concerned about those federalism issues. And it's just, you know, if the court says this is, you know, essentially a frivolous law, it doesn't accomplish anything, so it doesn't, you know, survive rational basis review. And on top of that, it's, you know, a departure from traditional assignment of these types of issues to the states. Okay, so this has no consequences for other marriage equality. Then, when it comes to Prop 8, what are the decisions the court might make? So, no standing. I think that's incredibly controversial. I think that's really a slap in the face of people in Western states everywhere who like to amend their constitutions, right, directly. But then that's right. That's no consequence no direct consequence for these issues.
If it was found no standing, what's the result? I mean, what?
We think that the district court decision is just, that's the governing law at that point.
because it was represented by the state still at that point? Or
Yes,
they already
yes, because you
dropped?
have two parties withstanding at that point.
Okay.
Okay. But it's not 100% clear that that's the outcome, but that's my best guess as to what the outcome is, okay? What else?
You know, they were asking how they could confine the
Yes.
decision to California, and I
Is
never.
Justice Kagan who was pushing on that? I can't remember.
Certain way where I thought,
Okay.
but who knows? But I never understood how they could.
Okay, well, here's how. If comprehensive civil union, then must allow same-sex marriage. And there's a lot of discussion of this, right?
Yeah, if you've gone 50% of the way.
And then just don't give them any rights ever,
Yeah,
and then you never have to deal.
This would be a terrible result.
Yeah.
This would be a terrible result. So I think they said it's 8 or 9 states that fall into this category. This would be a terrible result. Why? It creates perverse incentives, right? So now you're kind of punishing and saying, you know, you're behaving unconstitutionally to states that give more rights and encouraging other states not to give any rights at all. And put this against the backdrop of Colorado's recent decision to grant civil union benefits, okay? It comes out in a whole new light. But so, right, that would mean same-sex marriage is sort of required in these 8 states. And then, you know, uncertain, you know, states that have kind of a mixed bag of rights and benefits, kind of a tougher call. And then really creates an affirmative barrier to challenging marriage equality in states that haven't, who've only denied any types of rights for gay and lesbian couples. What part of the argument, what part of the equal protection flow chart does this go to? Where are we?
Is it the Romer Ninth Circuit argument? So is it the rational basis with a bite that if you give something, you can't take it back?
Yeah, it's a couple different places that you could put it, right? But I think where it belongs is here. Okay? It also belongs to this threshold question of, you know, the idea that the Equal Protection Clause is a mandate that those who are similarly situated not be treated differently.
Oh, so they aren't. So
If same-sex couples deserve, you know, all other rights, then denying, you know, the title marriage is sort of just purely arbitrary, expressive. You're saying, you know, that you're essentially saying, well, same-sex couples, yes, you are, you know, entitled to be in committed relationships and to have benefits that flow from that, raise children, etc. But, you know, we're going to sort of draw this line in the sand, right? I mean, I think this argument is right in the sense that it sort of highlights the arbitrariness, right? So the state is like, oh, well, we want to, you know, protect procreation, all these, you know, families, you know, just difference between, you know, the traditional norm of marriage and everything else. If you grant same-sex couples all the rights associated with those state interests, then it really gives lie to that claim that you're trying to preserve sort of separate, you know, realm or whatever. Does that make sense to people? People say other places where this argument resonates?
I've been thinking about due process clause. So there's just the separation between procreation and what marriage kind of means, and then the civil union, the whole civil union thing then starts to kind of mess with that attempt to say that, you know, it's a fundamental right, but it's not a fundamental right, and what makes it fundamental.
So the procreation issue actually comes up, yeah, a couple of places. I'm going to put it specifically here.
Couldn't it be rational relationship too?
And actually, I think that's actually the most important place. Under traditional rational basis review, must the state exclude from marriage all couples that can't procreate naturally? No, it can be radically imprecise in its tailoring, right? So that the court didn't really unpack all of this, but it's kind of talking about, well, if you exclude, this is the whole over 55 thing, right? Mm-hmm. If you exclude same-sex couples because they can't procreate, then do you not have to exclude the elderly, people who are infertile, etc.? Winning argument, perhaps under heightened scrutiny, including rational basis review with bite, but not under traditional rational basis review. There was another really interesting point in there about rational basis review and how it was characterized. You guys remember what case Olson cited for the standard for deferential?
Lee Optical.
Lee Optical. And this is fascinating to me, maybe not to you guys, but what's interesting about that?
What's interesting about it?
Did the court find that there was a rational basis for it?
The court, I'm sure that it did. I don't even, what Lee Optical mentioned in Loving, SEC versus Beach Communications, and Heller v. Doe, and Carolyn Products. Carolyn Products was a case about filled milk, right? We talked about this. Lee Optical was a case about optometrists versus optician.
Yeah.
Okay. SEC versus Beach Communications was about cable television providers, okay? And you have the court in these cases articulating this deferential rational basis review standard in an equal protection context, right? But they're all cases about discrimination between things, not between people. It's about people.
Committing people.
Yeah.
But it was about the standard of proof for that. So it wasn't, it was like one step away from.
It was about, how do we know it's about So when a court or an advocate wants the plaintiff to lose, these are the cases they cite for rational basis review, okay? If court, if the court wants, Romer is the sort of paradigmatic heightened rational basis review case, but which case you cite kind of tips your hand in terms of what you're trying to do, which version of rational basis review you're trying to actually argue against. And so Carolyn Products is the footnote 4, right? And it talks about discrete and insular minorities. Basically says, when we're looking at commercial legislation, hands off. We let the legislature do what it wants, okay? And they don't even have to provide reasons. We'll assume facts favorable to what they've done, right? And then it says in footnote 4, but this standard does not necessarily apply to discrimination against racial minorities, religious minorities, discrete and insular minorities, instances where the political process is broken down. And what that has been read to stand for is that a group seeking heightened scrutiny, something other than deferential rational basis review, has to show that it's a discrete and insular minority, that it's a suspect class, essentially. But there's an alternative reading of Carolyn Products in these other cases, and Heller v. Doe is the case that kind of cements this, which is to say that the fundamental distinction is between discrimination against persons versus discrimination against things. And if it's discrimination against things, then it's okay to have deferential rational basis review. But if it's discrimination against people, you need to at least have, you know, a little extra, right? Something a little bit extra. And then you have Heller v. Doe come along, and it very explicitly applies a super deferential rational basis review to a classification distinguishing between persons. But if you look at this case, all the citations are to commercial cases, tax cases, not cases involving discrimination between classes of persons, which is, I just find really problematic about Heller versus Doe. But you guys remember in Loving, the court, they're talking about the standard of review. And the state's saying, oh, this isn't really even an equal protection issue because we're treating the races the same. It should be rational basis review. And the court says, we are not going to apply the standard of Lee optical to race discrimination. So drawing this sort of distinction between discrimination claims in this commercial setting versus, you know, maybe it's just race that they're talking about, but maybe they're talking about discrimination between classes of persons as being fundamentally different. And that's what he was getting at in invoking that case. It's like, it's not appropriate to apply the standard of Lee optical to this situation.
God, all the things you would like have to know. I mean, like, that's like, you know. Tell me more. I obviously would know that, but if you weren't aware of that kind of discussion.
Well, that's what I'm saying. You know, that you look at this transcript. There's a lot
in there
going on in there.
Mm-hmm.
Yeah.
Well, how could some? I don't know. How could? Yeah.
Go ahead.
How could somebody participate without, you know, such a particularized knowledge about it?
Yeah. No, I mean, that's, you know, it's not really fair. I get super aggravated, even with SCOTUS blog and their coverage. I feel like it's really uninformed. This is incredibly technical stuff, and it has this history to it, you know. I'll tell you, the law clerk that gets to work on this opinion is going to have a really good time. They're going to be an expert in equal protection law. But, you know, the law clerk who starts working on it might not know as much about the law as you guys do right now, you know. You know, the clerks and the judges have to be generalists. And a really specific level of knowledge, I think, is required to get this right. Okay, so, not sure how we got off on the Lee optical thing, but like I said, this case could be all about rational basis review. And what is rational basis review? So let's go ahead and finish kind of sketching that out. So the court, so this would be probably this would be a rational basis review standard, right? That the court might characterize this as animus, which is different than the taking away thing. That has implications for one state, which is California. And I know that these diagrams make no sense. Hopefully you guys are following what I'm talking about here. But if a same-sex marriage prohibition violates rational basis review because it's irrational, because it's based on animus, only where the state gives and takes away rights, which is kind of what Reinhardt set up, that's it. It's not going to happen again. So it's kind of a scary thought. But it doesn't have the weird sort of perverse incentive, you know, effect of the first option there. The court, you know, embedded within this is the court could either invoke traditional, say traditional rational basis review, or rational basis review with bite, right? And that, I mean, this could be the moment at which the court explains to us what exactly rational basis review is and how to reconcile the different, you know, the different cases that are treated it differently. The court could decide, could engage with the heightened scrutiny issues. It could, did you guys see Kennedy has a very brief question, could this be considered gender discrimination? And then they didn't talk about it, which I was really pumped about.
Yeah, that was interesting.
But he asked Cooper that, right, but not Olson, and Cooper
think that's
says
right,
it's
yeah.
not gender discrimination.
Well, can you find the passage actually?
I know, it's hard, I wish there was.
Do you have an electronic version?
Yeah, but it's not searchable. So.
There's an index at the very end.
Oh.
Look for the word
Yes,
gender.
thank you.
Actually, I love this old-timey index. That is so cool.
I'm like, oh, control find.
13.6. So that's page 13, line 6. Do you believe this can be treated as a gender-based classification? It's a difficult question. I've been trying to. I want to write to Justice Kennedy like, yes, go there. We do not. All the courts have said it's not gender. But I guess it is gender-based in the sense that marriage itself is a gendered institution, a gendered term. I mean, yeah, of course it's gender-based. And so in the same way that fatherhood is gendered, more motherhood is gendered, and motherhood is gendered.
This is like
It's
the
gender
loving
nonsense.
argument though, right?
Yes.
That
Yes.
it's okay because we're discriminating against women and men.
Neither one can marry a partner of the same sex. Which is not, you know, is there a facial classification? What is the facial classification? That's the question, right? I mean, after Brown versus Board of Education, we don't look at differential burdens. Okay, so if the court, you know, does decide to go down the path of saying it's gender discrimination, you know, that is what you will have. I mean, essentially, that's a nationwide ruling, because yes, in each state, the government could contend, okay, you know, we actually can survive intermediate scrutiny. We have an important state interest, and this law is substantially related to it. Theoretically, each state could come up with a different justification. There could be a patchwork in terms of outcomes. But the states are having so much trouble coming up with justifications for these laws. You know, I mean, you can see it with DOMA, you can see it with Proposition 8. So even though this would just be intermediate scrutiny, theoretically some states could overcome it. I think it's basically a nationwide ruling.
I think I still kind of have, can you just like sum up the gender argument? Like,
Okay, so it's gender discrimination. There's something up.
Didn't you say earlier it's on its face?
Well, you look at the facial classification. Okay, so first of all, there's two different equal protection shoes. Facial classification, discriminatory impact. If you're a discriminatory impact, you're screwed, because of Washington Heights and these other cases, you have to show this super evil discriminatory intent, right? Otherwise, you get rational basis review. But as soon as you have facial classifications of persons, you get whatever level of scrutiny is associated with that classification, okay? So how does the court determine what the classification is? And I think Loving is the case that really, you know, demonstrates that. The court in Loving did not ask whether a propensity to want to be involved in interracial relationships was a suspect classification. It said that the classification of the issue was race because rights and burdens were being regulated by race. That was the operative term. And it's the same thing here. These laws do not regulate on the basis of sexual orientation. They determine rights and responsibilities based on gender. That's the fact. You know, no one comes in, when you come into the courthouse, they don't say, what's your sexual orientation? They say, oh, you're two women. And that's why you can't get married. I mean, I don't know if that's really, does that get it all to what you're?
it does.
Okay, and so, you know, again, if the courts are saying it's not gender discrimination, are saying it doesn't impose differential burdens, and it's not animated by sexism, which is really untrue when you look at the justification that the government offers or the interveners offer, that they want to preserve differentiated male and female parenting roles as the ideal kind of parenting roles. That's sexual stereotype. So it is gender discrimination in that, not just in a technical sense, but in a substantive sense as well. And yeah, and a lot of people feel like, you know, sexual orientation discrimination and sex discrimination ideas about gender roles, sexuality are really intertwined, and they're not, you know, so distinguishable. So the thing I think is appealing about the gender argument is that then you don't, you know, it doesn't open the door to challenges based on polygamy. Did you guys see what Ted Olson said about polygamy? He said that's conduct, not status.
Yeah.
I mean, good for him, but it's, you know, it's really this sort of oppression Olympics, right? Where it's like, it used to be a sexual orientation was conduct, not a status, and now it's like, oh, we're not like them. We're not like polygamists because that's conduct, not status.
But isn't it about more about kind of the argument that you make you have to have a limiting principle? I mean, his other limiting
Look, like
principle
who's
could have
going under the
been
bus when you do that?
That's polygamous.
I mean, somebody else, right?
Yeah, but
And I
what
said
else
that-
could his limiting principle be? Because their argument's like a slippery slope argument, and don't you, I mean,
Well, I
you got
think-
that with a limiting principle, and if you don't have a limiting principle, then, I mean, you would just say, well, we're just discussing this here.
Right. I mean, and yeah, and I remember literally sitting, you know, in the Vermont Supreme Court during those arguments, and that's exactly what happened. You know, that's why the way you end the slippery slope argument is, you know, that's not before us today.
And that's why, like, I mean, there's been criticism of certain LGBT groups for throwing transgender rights under the bus.
Yeah,
To
there's,
say,
yeah.
like, well, that's not us. That's
Right. You know, we're normal, we fit in, you know, we want to get married and have kids and blah, 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 right? So the freaks are kind of, you know, pushed ever to the outside. I mean, I think there's, you know, that describes a dynamic of social evolution. That describes a lot of what you see in equal protection law, right? So, you know, you're comparing, this is, I think, just so ironic. Equal protection law takes social groups and organizes them hierarchically. It discriminates between social groups and their sort of worthiness in terms of additional judicial solicitude. So it's kind of hard to escape that dynamic, but I think it's problematic because it doesn't. What happens then is the state of the law just reflects, okay, we finally reached a consensus now that it's not, you know, it was okay to discriminate on the basis of race, then it became not okay. It was okay to discriminate on the basis of gender, became not okay. Same thing with sexual orientation. We're just waiting, you know, we're not leading, the court is not leading with principles of justice, it's just waiting for society to decide that it's not okay to discriminate against a particular group. There's no transcendent principle of how do you recognize unfair discrimination outside of that social consensus. Okay, so, but go ahead.
Yeah, how does conduct work in this context? Because
Yeah.
Well, and wasn't that, I mean, kind of dangerous? Aside from that, was saying, because isn't it still debated whether it's conduct or?
Yeah, so that's an interesting
and
issue.
it's the act of marriage. Like it's not.
Yes,
It's not being homosexual that's not allowed. It's the act of marrying, which seems like conduct rather than status.
Well, they're saying you can't choose your partner versus you can actively have multiple partners or choose.
You guys are heading up against, I think, a really difficult question of what is the status-conduct distinction. And I talked about before with felons and ex-felons. You know, at what point does that stop being conduct and really transform into being a status? Is it you can't marry because you're gay, or is it you can't marry someone of the same sex? Is it you can't marry because you're polygamous, or you can't marry 5 people? I mean, a lot of it has to do with the framing of the question, right? I don't think it's at all clear that polygamy is conduct, not status. I think it's directly parallel to sexual orientation, you know?
Yeah,
but,
it seems the same. I mean, either way you go with it, it seems like the same sort of decision. Although you can't,
You know, I don't think there's like scientific evidence that you could be born a polygamist. You know, it's like.
But you're, yeah, but you know, so you're not born, you know, Scientologist or, you know,
yeah, I mean, it is a little bit different in a sense that, I don't know.
Well, so the court really didn't talk about suspect classification analysis. Oh God. It did a little bit. Sort of talking about, you know, we were talking about the scientific literature on sexual orientation, that it's now kind of consensus that it's status versus conduct, you're born this way or whatever. And people like Janet Haley, I think sent that article to you.
Yeah.
It's really kind of messed up, in a sense, to say you're not capable. I mean, it's sort of paternalistic to say you're not capable of choosing your sexual orientation. But of course, strategically, if you want to fit into the whole immutability framework, you're supposed to claim that. And not just immutability, but the idea that burdens should correlate to individual responsibility. If you're not responsible for your sexual orientation, you shouldn't be punished for it.
And that's throwing bisexuals under the bus.
Yeah.
I mean, that's like saying you're either or, you're born this way.
Yeah. Or people who experience evolution over the course of time. I guess they're technically bisexuals, but might be thought of as a different category. Nothing in the oral argument suggested to me that they were going to treat sexual orientation as a suspect classification, but there was that one passage. You guys remember the passage about, it was really great, where, was it Sotomayor got Cooper to concede that sexual orientation was not irrelevant to legislative concerns in any other context outside of marriage? So, with suspect classification analysis, you guys have, history of discrimination, immutable trait, political powerlessness,
ability to contribute to society.
Ability to contribute to society. Discrete and insular minority. It's easy to forget them because they're applied differently in basically every case. But in the articles that I gave to you kind of say, well, immutability and political powerlessness are not really the focal points that they used to be necessarily. And especially the gender cases say that it's wrong to discriminate on the basis of gender because gender generally does not correlate to one's ability to contribute to society, right? And then have on the other side Claiborne saying mental disability does generally have effect on the ability to contribute to society, so that can't be a suspect classification. So if Cooper concedes that sexual orientation is irrelevant to the vast majority of legitimate legislative purposes, that's almost close to conceding that sexual orientation is a suspect or at least quasi-suspect classification. And I think that's the strongest argument for sexual orientation being that and history of discrimination. The other factors are a little bit more tricky. There's so many political costs, though, associated with declaring sexual orientation a suspect classification. I just don't. I mean, that's where a lot of the academics want the court to go, but I just don't know. I'm not sure that I see that.
What do you mean by political? Like a lot of political costs?
Well, so this is where Kenji Yoshino wrote this article about pluralism anxiety, and I talked to you guys about how the court sort of really just solidified suspect classification analysis in 1971, and then in 1977 was the last time it recognized a suspect class. So, what happened was you had lower courts being like, everybody was a suspect class, right? Poverty was a suspect classification, blah, 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 blah. And the court's like, no, we're shutting this down, basically. That to recognize sexual orientation as a suspect class would encourage a lot of litigation about other suspect classifications, and then you're going to get into intersex individuals and transgender individuals and lots of lawsuits, about those issues and seeking suspect classification recognition there.
Yeah, I mean, especially if it's already such like an amorphous class, it's like how do you say sexual orientation is a suspect class? I mean,
well, this is the whole problem.
Classification.
They're two really different theories of suspect classification analysis.
Yeah.
One is that it has to be this discrete insular minority, identifiable group, Women don't fit that criteria. No way. I mean, you could not have a more diverse group than 51% of the population, right? But that's a sort of like deservingness model of suspect classification analysis. It's like, are you this poor, oppressed social group, blah, 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 blah. And then on the other side, you have, is this trait relevant to sort of two ways of thinking about it. Is this trait relevant to, generally relevant to legitimate legislative goals? I don't care how diffuse and diverse the group is. Gender, we've said, it's not relevant. The sexual orientation, I think there's some emerging consensus that it's not relevant. But another way of looking at that relevancy approach to suspect classification analysis is this sort of idea that you can regulate conduct. but you shouldn't regulate on the basis of status. If you're concerned about excessive drinking and driving, regulate drinking and driving. Don't limit access to alcohol based on the gender of the person, right? In Craig v. Boren or whatever. You know, from Claiborne, if you're concerned about overcrowding in group housing, regulate overcrowding. Don't draw a distinction between the mentally disabled and those who are not. You know, so there really are two fundamentally different paradigms for what, you know, why we're concerned about suspect classification, and that those would play out really differently for sexual orientation. Because on the one side, it's crazy to think about this as even an identifiable class. On the other side, you know.
So are we saying sexual orientation in general or homosexuals? Because if we say sexual orientation in general, then we're putting heterosexuals into a group as well. And
Yes.
What's the point of that in this case?
Well, as you know, this is one of the fundamental sort of irrationalities of suspect classification analysis. When the court declares a suspect classification, it looks at the characteristics of the outgroup, right? History of discrimination, political powerlessness, etc. But then when it goes forward to apply suspect classification analysis, it's symmetrical and ahistorical, right? So it's not that African Americans are a suspect class. It's that race is a suspect classification. And it's, you know, the court will say, well, are homosexuals a suspect class or an oppressed class? But the doctrinal result will be that sexual orientation, okay? And then the question is, does sexual orientation include just homosexual and heterosexual? Does it include polygamy? Does it include whatever? If you suddenly say you can't discriminate on the basis of sexual orientation, what consequences there? But yet there's a disconnect between the factors that determine suspect classification recognition and then the doctrinal application of that going forward.
Well, and if you apply that, the second analysis you talked about, so if you're interested in regulating, I mean, the application here, I can think of two, would be if you're interested in regulating marriage, regulate that, but more their argument is if you're interested in regulating procreation,
then regulate that.
But
and then that kind of comes back to level of scrutiny.
Okay.
Because if it's strict scrutiny, yeah, they're totally messing up in terms of regulating procreation. If it's rational basis review, good enough. You have this crazy idea that you can get straight people to marry and have babies within marriage, good enough for rational basis review. Okay. Then the fundamental right issue as well, that's really messy. I mean, that's, of course, you know, people kind of like that idea because of the analogy to loving, but if you say marriage is a fundamental right, that opens up challenges to all limitations on marriage, including incest, consanguinity, age, you know, whatever. But that would also be a nationwide solution. What would you guys do? I mean, I can't believe I'm going to say this, but I read this transcript, I felt sorry for the justices. I was like, this is really hard. This is really hard to decide what's kind of, and they could go a lot of different ways. You know? What should they do?
And they're forced to actually make like a hard decision here. I mean, it's like
It's really hard.
they're gonna create new law, I think, almost to get to a final decision, almost either way they go.
Unless they go with gender. See, that's why gender's a conservative choice. Gender fits in the precedent.
I just think it's hard to fit it in there, though.
I think it's so easy.
Is that what you would do?
Well, actually, I want to write a little piece on this. Obviously, you know, animus is kind of the issue I'm interested in, but I think I was talking about it with a couple of you right before class started, but I think it'd be very interesting to decide it on the basis of animus as evidence in the record, right? Because then you don't have to deal with suspect classification or fundamental right. It's state specific, but other states could prove it, but it's not necessarily a nationwide ruling. So that's what I would.
And when was Romer?
They really didn't talk about that at all in
just-
all arguments.
Well, it's interesting. So of course, when the argument came out, I did a search for animus, or I looked at the index, and I was like, and then they did talk about it in the DOMA case. But I don't think argument precludes, you know, sort of certain issues from being part of the ultimate decision. And it's it's the sort of centerpiece of the Ninth Circuit decision. So, but yeah, it's bizarre. I mean, I really had wanted them to talk about that issue, and they didn't. But so yeah, other thoughts. What would you do? What would you do?
rational basis.
Right.
Right.
Okay. And would you justify using rational basis with BITE, or would you just pretend that that's, oh yeah, everybody knows this is actually what rational basis review is? And then you'd have the dissent being like,
well, I think
that's
it
not
goes
rational
along with
basis
what I would
review.
choose
Yeah.
as my topic, that it's kind of talking about the fundamental idea behind the Equal Protection Clause is liberties, and that you don't want to create an underclass or I think that's really what I would do.
Okay.
Because I think the problem
So
with...
this is discrimination for the sake of discrimination.
Yeah. I think the problem with doing suspect class, opening it up or not, is that to become a suspect class is so difficult that you really do have to have some type of consensus somewhere, and I think just precluding it that way, we get to this like limited category of is problematic.
Yeah.
Or because then, you know, as time evolves, if it's always that you have to be a suspect class to get
Any kind of review.
yeah, it seems...
No, I mean, in terms of the evolution of equal protection jurisprudence, I would really like to see the court avoid suspect classification analysis, because I think basically it's all or nothing. You know, you have this few, in a sense, privileged groups that get suspect classification designation, and they get meaningful rational basis review, and then nobody discriminates on that basis anymore. Okay.
But then the ostracized groups continue to, you know, either come to the surface or, you know, or people become aware of them, then they become suspect. I don't know.
But the court's going to stay, the court's going to be like, oh my God, too many groups, we can't do this anymore.
Yeah.
You know, so it's a self-limiting mechanism that doesn't really respond to evolving social prejudices. Do you have a point?
It just seems like if you get into that, you're almost like, I mean, what is it called, like Little Giants? Like it's like the exact opposite of what they're trying to do. It's like you're equal protection, but only applies to these people. It's like they're discriminating and creating classifications to apply to equal to all human beings type of law.
Yeah.
Or like doctrines.
And the court has avoided doing exactly that. The court has avoided sitting down and saying, what is invidious discrimination? Instead, we'll create these categories and this doctrine, and it's like, it's fun to teach because it has this great structure, and whatever, but you know, it's incredibly rigid, and it precludes meaningful review in the majority of cases. Other thoughts about what path the court should take, or what you would do?
Well, you brought up something too this time for me. I was pretty still on rational basis review, but then like looking at, like, I almost have to go like rational basis review with like a bite, like, and kind of define like what that is. Because then going into these like Carolyn and Leopicals, like once you get into like an economic reasoning, the level there is so low that it's like, that is, I mean, you're kind of creating another classification too for like what review to apply, but it's like when you're dealing with people, like laws that affect people versus an actual like economic rule, and it's going to apply a different standard.
I would love it. That would be another thing I would love to hear the court say. Is, hey, you know, we need to figure out what rational basis review is, and let's start at least with drawing a distinction between discrimination in commercial context versus discrimination among groups of persons.
I think that's difficult though, because even in the cases that deal with things, are still tangentially dealing with people. In the case of dealing with people, still tangentially deal with economic issues. I think it's really hard to totally draw a black line right there.
Really? Interesting.
Particularly Heller v. Doe.
Well, Heller v. Doe is dealing with people. That I put it under things because it's deferential rational basis review. That's definitely dealing with people, and I think it's a great.
So that one for me kind of bridges the gap between the two, because
yes,
it was very deferential. There's a really good level of analysis there, I think, and I think that they came to the right conclusion that it was that the categorization of people for, you know, various rules did make sense. They looked pretty closely at it.
They
looked at the record, they looked at the lower court decisions, they really looked at it and came to, I thought, a pretty reasoned conclusion there.
Reasoned it was.
And so...
I don't know. I think, you guys know that I have a crush on Claiborne. I mean, I think Claiborne is actually a great model for meaningful rational basis review because it does that kind of close analysis. You know,
well, and it was. I think Claiborne's interesting because it also kind of bridges the gap because it's zoning codes. It's, you know, a decision made under a zoning code that's being challenged. It just happens to affect or have been potentially based on animus towards a certain group. And so what they're deciding is an administrative decision under a zoning code, but it still has an effect on people. And so,
Interesting, that's interesting, I hadn't thought about that.
Yeah, it is pretty tough to distinguish like purely economic or purely people-based. I mean, because
Facial classifications, I don't know. I mean, I just think it's a different battle, right? Like, let's say in FCC versus Speech Communications, regulating cable companies this way had an effect on, you know, racial minorities or something, then tackle that in that context. But if it's said on the face of the law, you know, group A gets this, group B gets that, you know, defined by this particular characteristic, I don't know. We're out of time. Other thoughts? Other gut responses? And it's not about your paper necessarily, but just based on our discussion today and the choices the court's facing.
I still think it fails rational basis review because I think that the government definitely has a legitimate interest in regulating things via marriage or some structure like that. But the way that they chose to get there just is a disconnect.
Okay.
So
Okay.
I think even under a pretty deferential and rational basis review standard, it's just a misfit. And I don't know, I've been thinking a lot about the burdens because it seemed like in Romer the burden was on the government, and it seems like in these other cases the burden's on the plaintiff.
The official word is on the plaintiff, but the court does not always act that way.
No. And so I think that under rational basis review it does make sense to articulate a rule where the court is not going to dig into legislative intent, legislative motives, you know, the reasoning for doing things until a plaintiff meets a certain threshold to call it into question. So I almost think that, and I put this in my outline, that like a burden shifting system might be better, where the plaintiff has to raise enough of a question about the government's motives or the connection between the legitimate state interest and the way they chose to get there. And then once they kind of hit that threshold, then the court's got to look at what the government has to respond, I think, in my opinion.
Nice, okay, very creative.
But if it's...
I love burden shifting, right?
Yeah.
It's always like, I've got a burden shifting test.
If it's procreation, I mean, they have a legitimate state interest.
Yes, and it's rationally related.
Yeah.
Yeah.
So, I don't know how you
Depending
get
on what you
around
mean by
that.
rationally related.
Yeah.
It's all about the standard of review, or level of scrutiny, rather, you know. On that, you know, and I hope the court will take the gloves off and really recognize that, but I don't know.
yeah, that's where I was like kind of inclined to put in like a burden thing, like a burden on the classification as a rational basis review, as a kind of a standard. But I think that's going to continue to be defined too. What's a burden and what's not.
Maybe if they're making a facial classification, the burden should be a little bit, as opposed to just regulating something that has an inadvertent
Facial
effect.
classification of persons, I think you're in a different territory, and I think the burden should be on the state because the whole idea of deference, you know, is essentially abrogated by the mere existence of the 14th Amendment, right? And when you don't require the state to articulate classifications, the state doesn't have to provide reasons, and that sort of weakens the process. And then you don't have the adversarial system really working. Because one side doesn't have to do anything. The judges can kind of fill in the blanks for them.
That's problematic, I think.
Yes. Feminist says problematic. You guys want that blog? A feminist looks at these different things and she always concludes problematic. Great. This is such a pleasure to talk about this stuff with you guys. Thank you so much. And if you have other thoughts about, you know, I think the oral argument really informed our discussion today.
Justice Thomas didn't speak at all.
He never does.
He never
He
does.
spoke
Once.
recently and it was like a joke or...
Yeah, he said 4 words.
never
in
does?
January,
How
right?
is it okay? Like everyone's talking and he, like, I don't know, I mean, there's no...
Yeah,
I was like trying to guess by their comments, like which way I thought they were going.
Yeah.
Obviously, you should maybe have an idea about most.
Yeah,
But
yeah.
Something monumental.
he didn't say.
But it's like that thing, he never speaks.
No, that's
but
right.
How is that okay? I mean, no one's
Why
Why
concerned.
is that a thing? Why?
Yeah.
This is a stupid
Well,
thing.
he was, you know, so scrutinized and sort of, you know, people from Yale were like, you're not really as smart as the rest of us. I mean, I don't know.
So not talking is a good way to show people
Well,
who you are.
but, you know, I was like,
Did he not go to Yale?
he did. Yeah, and they're kind of like, you know, you're not really up for this, you know, the way other Yaleys are. I mean, it's, yeah, no, I mean, I'm not going for him, but, yeah, or just maybe just like, kind of crushing self-consciousness, you know?
It comes off like he does not care.
Yeah, no, I mean, I think it's not.
That is
good-
offensive.
No, I think it's not a good practice, for sure. But, you know, it's gonna maybe also like, once you start going that direction, that's kind of your